this one for 3 years. There was nothing wrong with him. Roe versus Wade. The decision comes down like we knew it was going to happen. I said to you, the draft opinion by Alito, it's going to be different than the final version. And it was. And nobody is mentioning how different and why it's different and what's important about it. The difference is that the Alito decision now, because they debated it over the last several weeks as to how it would affect other cases. Because if you say that Roe versus Wade, which is an interpretation of the 14th, and therefore is an presumed right, which it isn't, because they said it's a bad decision. Then you can use that defense for just about anything, including every federal bureau there is, every ruling on gay marriage, every ruling on sexual preferences. You could even use, in theory, the law against Jim Crow. You could say that the Supreme Court decisions on Jim Crow were entirely wrong, too, that the states have a right to determine Jim Crow, except there was one problem. That was the draft. The draft opinion left out any discussions of any interpretations of the Roe versus Wade reversal and other laws. That was changed. Samuel Alito wrote a long, lengthy section, and it was summarized in one paragraph at one point, that you could not use it because the difference between this particular decision, which is a presumed right of the 14th Amendment, and the others is there are constitutional and legal precedents, and it does not concern a third person. In other words, the Roe versus Wade decision is not a reversal of abortion. And he specifically says that in it. It is a return to a discussion at the state level. All right? And when you do that, you have to make certain caveats and certain assumptions at the federal level. And he went into that and he explained, he said, well, no, you understand that the decision on Roe versus Wade, in theory, was based on a decision of two people, the doctor and the patient. And that the government can intervene in that or can't intervene in that in order to prevent an abortion from happening. In other words, two people were conspiring to commit murder on a third. And that's why Alito phrased his opinion in that manner. It involves a third person. And you didn't address the third person in the original ruling, because the original ruling in 1973, it was a different standard. And I will get into that in the history of abortion. It's really important. Why? Because our views on abortion have not changed in this country, but our science has. Why that's relevant in the decision. And I think it's important that people understand it. But meanwhile, of course, the Democrats don't explain anything to anybody. They don't want you to understand the ruling. They want you to get angry and get mad about it and get frustrated and think that the government is telling women what to do with their body. They're not. Women are free to use contraceptions. Women are free to use other methods to prevent abortion, to prevent pregnancy. And that's where the decision has to be, because there's a third person now involved. The decision affects the Missouri ruling, which says we can regulate abortion after 15 weeks. Women up to 15 weeks in most states will be allowed to have abortions up to 15 weeks. There are exceptions. Some states will ban it outright, such as Oklahoma. They've already introduced legislation to do so. But you understand that they're talking about birth to 15 weeks. At the standard at the time in 1973 was 23 weeks or the quickening. And then we'll get into that again in the history. And so that's changed, and that's why the ruling has to change. Now, Judge Roberts, for his part, didn't want to overturn Roe versus Wade completely. He wanted an opinion specific to the Missouri law. And I would kind of lean that way, but I understand why they overruled it. You know, the Supreme Court doesn't have to necessarily overturn Roe versus Wade to let the Missouri law stand. They could simply say, well, this is just a natural regulatory procedure of regulating abortion as per the Roe versus Wade decision. You have to go back and read it. Roe versus Wade said that the individual states will be still allowed to regulate abortion, that abortion will be rare, it will be special, it will be not an issue, and that's what they believed in 73. And that has changed. And Roberts wanted to keep the 1973 standard alive. But he was signed aboard the Alito decision. Well, look, I understand. Because when you start to regulate to a point where you start to narrow it down to such a narrow level, you might as well abolish it and simply say states can do whatever they want. If Missouri can regulate abortion above 15 weeks, then Oklahoma can simply say, no, we don't want it at all. Then you're talking against yourself, which is what all of this is, a very complex situation. And the decision was basically, we're going to get out of the way. The federal government is going to get out of the way of the democratic process, which is you go to your state legislature and you make your case of why you should have abortions, why you shouldn't, where it should be regulated, and that sort of thing. And then states will be free to do what they want, including 15 weeks, 17 weeks, or simply hold to the 23 weeks, or simply, and that's really what it is. There's no reason for people to get angry. And it's interesting because the left is going nuts and completely misunderstands the argument and is screaming all the time on TikTok at the top of their lungs. Well, that's not an argument, okay? You can't walk into a courtroom. You can't walk into the legislature and say, no, I want an abortion because I'm mad, because women have the right to do what they want with their body. Yes, they do. But you also understand that human beings don't have the right to do whatever they want with their body. You can't kill someone. You can't shoot someone. You can't rob a building. There are things you can't. For instance, in the vaccine argument, you can't do whatever you want with your body. They're going to mandate vaccines because it's for the betterment of society. That's the legal argument. I'm not making a personal argument here. I want you to understand, this is a legal argument. We are a nation of laws. If you don't like the law, you can appeal. You can change the law. You can vote it the way you want. You can petition your legislature. You can do a state petition where a popular vote is involved. There are all kinds of ways to change the laws in your state. There's no reason to get angry about it. And there's no reason to say another state can't live the way they want to either. But of course, the left has gone nuts because nobody has the subtlety of thought in the process. You cannot do whatever you want with your body, man and woman. You do have limits, societal limits. Just as, Joe Biden famously said, well, you can't yell fire in a crowded theater. Yeah, there are certain things you can't do that might be damaging to people. One of which the courts and the laws have found, like vaccines, and the same thing with abortion now. It's up to the states to determine what they feel is the standard that should be in their communities. What could be a more democratic process than that? And the Republicans are making that case, but unfortunately you get some people out there that are screaming about, it's immoral to kill people. Look, you know where I stand on this. I don't believe in abortion once conception happens. But you have to understand, I have also recognized the value of a law. And I may make a petition. I may file a brief, an amicus brief with the state legislature here in Arizona that we should just ban it outright. I may do that. I might. But that doesn't mean that I'm going to simply get angry about the law, just like Obamacare. You don't have the right to do whatever you want because Obamacare exists. The state HHS has a right to determine health insurance codes in your state. So you don't have a right to do just whatever you want. The interesting thing about this was the Thomas decision. Thomas signed on to the main decision, Alito's decision. He agreed with all of the premise. In other words, for a Supreme Court, to make a ruling, each individual justice has to sign aboard the majority opinion written in this case by Samuel Alito. But they can also find something and write a brief, which is called a concurrent opinion. And they can make exceptions that they personally feel should be also on the table or not on the table. And it has no legal relevance. It has no legal argument. It means that argument was brought up in the discussion with the 9 judges and was rejected. That's what it means. That no, we're not going to go with Thomas's opinion. We're going to go with Alito's. Because we feel, as a whole, the 9 justices, and even the liberals have to agree to all these things, that this is not a valid argument. But they file each individual argument. They file a brief. Just to tell you, well, this is what my thoughts were on that table on that day. Or that days. And Thomas said a very controversial thing. He says, if you're going to file and say that Roe versus Wade does not exist as a constitutional right, because that's what you're doing by repealing it, then you could also make the same argument for many other things that we do involving social engineering cases, such as gay marriage or sodomy laws or even Jim Crow laws, if you legally parse it out. And he said, you understand this is a concern of mine. I personally think that he's a hardcore literalist. If it's not in the Constitution, you can't do it. States do it. But he still signed on to the main opinion. And that's what liberals are not being told. Everyone's going nuts because, Judge Thomas wants to go back to the 13th century and this and that. Doesn't matter. He signed aboard Alito's decision. That's the law of the land. Now, if you get 5 Judge Thomases, you might have a situation where a case might come up, in which case it reverts back to the states. But understand this. You had people on that court like Amy Coney Barrett and Brett Kavanaugh who are hardcore constructionists. Same with Alito. And they didn't go along with Justice Thomas. Justice Thomas has his right to opinion. It's all it is. Because he signed aboard the main opinion. Most people don't understand how the Supreme Court works. It's not they just vote on it. No. They file briefs. They show their arguments. And then the main argument, the published argument, which Alito is the one that is law. Or an interpretation of law. And he said social engineering belongs in the states. I agree with him. I'm like that. I have a very firm view of the Constitution. It's up to the individual to state to decide what to do. And you understand that nothing has changed. People could still get an abortion today just as much as they could yesterday. That will change with time. You'll see some states that will allow abortions up to the moment of birth. You'll see some states that say no, at the moment of conception, life begins, and so therefore abortion is 100% legal. They will be few. The two extremes will be few. Most states will regulate it between 10 and 20 weeks. And there's a reason why. Let's get into the history of abortion and why they chose that time. It's not just, well, we did sonograms and saw it was a baby. No, there's more to it than that. We'll be right back after this brief break.